All right, all. It's June 5th again. Welcome to the start of criminal law evidence and procedure here at John Tyler Community College, summer semester 2017. Let's open up our books to page 2. Let's start going over chapter 1's information. So follow along. We also have the PowerPoint that I put up there for you that will help you keep along with what's going on here. Highlight a couple things that I want to make sure that we're reading and we're familiar with for our discussion boards, for our quizzes and for our midterm and all that. So starting on page 2 here, chapter 1, where I have a couple modules in chapter 1 to go through in the book. So keep that in mind. It is a little bit of a lengthy intro chapter, but it does cover some good stuff to get you going on. Make sure you're understanding the difference between criminal law and criminal procedure to begin with. What do we mean by criminal law? What do we mean by criminal procedure itself? Think about what it means to be in the United States criminal justice system, what it's like to go through the legal system, whether it is as a defendant or what the roles are as a prosecutor, and whatnot. As we go forward in this course, we're going to explore all those different, avenues, all those different terms and whatnot. So make sure you're familiar with those two main definitions there. Looking at some of the things we're going to talk about, we're going to start talking about defense. We're going to talk about prosecution. We're going to talk about the concepts of each and the roles of each. We're going to talk about, like I said on page 3 here, the classification of crimes, what it means to have a felony, what it means to have a misdemeanor, what those two terms are, and make sure they're not being used synonymously. They are two very different things, right? That leads perfectly into page 4, mala in se and mala prohibita. Talking about the act itself. Are we talking about is the act evil? Is the act wrong in itself by without anything else to it? So let's think about rape, robbery, murder, that stuff. That, for the most part, can be understood to be an evil act, to be a wrong act. If you look at the idea of mala in se, in the plural of malum in se, the act itself is wrong and evil. That's not a lot of debate on that. However, when we look at a lot of the other crimes that are out there, depending on the jurisdiction, depending on the civilization, the society that we're living in, the act itself can be considered to be wrong or right, or even less than wrong, depending on the society itself. When we're talking about that, we're talking about mala prohibita. The act itself is not necessarily evil or wrong, but it's defined as such by that society or by that law. Think about some of those things here in the United States. Maybe it's jaywalking, crossing crossing the road illegally. A lot of places that might not even be illegal, but here you could get in trouble for that. Some societies, the big one to talk about, drug usage, right? Talk about a lot of our crimes that are considered to be victimless crimes. Some places they're prohibited, some places they're not prohibited. What does that mean, and so forth and so on. Pages 5 and 6 get into the history and the background of our law and our procedure, going back to the earliest ideas of eye for an eye, Code of Hammurabi, the 12 tables, the Justinian Code, our English common law in the United States system is so much founded on. So many of our definitions have come from there, right? We have to understand those. We have to understand what it's like to have the law already set down. Like you see in page 6, it talks about precedents, stare decisis, standing by already decided matters. We have to talk about, this is the model penal code, and ultimately we're going to get into the United States Constitution. We're going to get into all the different amendments, how they play a role in our justice system, in our lives. Specifically the Bill of Rights, the whole idea of our protected rights, in the Bill of Rights. We're specifically going to hit on 4th, 5th, 6th, 8th, and then a little bit outside of the Bill of Rights, the 14th Amendment and incorporation and whatnot. So, what do we mean by due process? What do we mean by our rights guaranteed to us and our to protect us from cruel and unusual punishment, from search and seizure, from double jeopardy. What do these things mean? We're going to talk about them this semester. You'll see the breakdown of the amendments 1 through 10 on page 8. So let's keep flipping through. Start looking at page 10. Some of the core concepts in reaching a verdict. So we're going to talk about what it means to be in an adversarial justice system, what it means to be in an inquisitorial system. Good Lord, I cannot say that word. System. We're going to talk about our levels of proof, reasonable suspicion, probable cause. In the civil side of it, we're going to talk about preponderance of the evidence. We're going to talk about guilt beyond a reasonable doubt. What does that mean? Where does the burden fall? Where do the assumptions of guilt and the presumptions of guilt, where do they fall? How does that work? So that's all in pages 12 and 13 here in chapter 1. Talk about what it means to have an opening statement. Talk about what it means to present evidence, the difference between real evidence, direct evidence, circumstantial evidence, indirect evidence, testimonial evidence. It's all laid out for you. I want you to take away anything you have in your head from watching TV, from watching Law and Order, from watching, you name it, any one of the numerous movies and TV shows on court systems, because you're getting the dramatic side of it. You're not necessarily getting the procedure side of it, right? Those shows are meant to be interesting. However, for anybody who's ever actually sat through a court case before, you can understand how sometimes they can be very boring, but there's a very important role that procedure plays in them. So when you hear all these different things when you're watching TV, you got to take it with a grain of salt. Just like when you read things and you look up your sources for your discussion boards here, you got to take them with a grain of salt. But we have to make sure we're understanding the definitions of each of these as we go. So going forward, what is meant to have a bench trial, a trial by a judge? What is it meant to have a trial by jury? What do we mean by grand juries? All that stuff's in there. The Sixth Amendment right to a speedy and public trial by a jury. What do we mean by that? That's page 17. So read over that. What do we mean when we're selecting a jury? What does it mean to have a jury that can't come to a verdict? What does a hung jury mean? All that's laid out for you as we read along here. What are some of the ethical dilemmas that are associated with juries and jury nullification, jury vilification? That's talked about briefly on pages 19 and 20. To finish up, chapter 1 talks about the organization of courts in the United States. We are a dual court system. We have states and federal. We have state courts. We have federal courts. Powers lie in both state and federal. How do they work together? What does the federal system mean? What kind of jurisdiction do we have? If you think about shoplifting, we'll throw that out there. How does that originate? Does that start in our lower courts, in our general district courts, and work its way up the system? Where does it go? Things don't just go to the Supreme Court. People think, I'm going to take this to the Supreme Court. How does it get there, right? So it lays out the levels of Supreme Court. From the top level of Supreme Court all the way down through our like in California, the superior courts. In Virginia here, our general district courts, even our juvenile and domestic relations courts, up through circuit courts, up through courts of appeal, into state Supreme Courts, ultimately into lower level federal and trial courts, through Court of Appeals in the federal system, all the way up to the federal Supreme Court. So let's make sure we have an understanding of how that system works rank by rank. What each one of them has the right to do, what the responsibilities of each one of those do, what it means to have a case heard and have a case sent back, right? So when we talk about prosecution, we talk about defendants, we talk about what it means to be an appellant or to be an appealee or appellee. So if you hear that a case was appealed and it was remanded, what does that mean? When we hear that a case was reversed or a sentence was vacated, or even a sentence was affirmed, what does that mean? What do those words mean? Which ones can be used synonymously? And we have to have a clear understanding of that before we keep moving on here. So flip over to page 28 to finish up chapter 1 here. what does it mean when in the Supreme Court? What does it mean when a judge gives their opinion? What does it mean when they dissent, when they concur? What do we mean by those cases, those case briefs? What do we need to know about those terms? To sum up, page 29. To sum up, what we meant in that. Make sure you read through these summaries, have a good, clear understanding of them, and be familiar with all these terms. I know it's a lot in Chapter 1, but we got to get that foundation built before we can continue to move on.